Welcome to Legal Refreshers at Roll Call. This will be a series on a First Amendment review. Disorderly conduct and First Amendment auditors. Officers will be receiving calls that implicate whether it's speech only or an actual crime. Some of those calls may be somebody's yelling profanity or hateful things in a public area of which the police are called to. Or it may be assemblies of persons saying hateful things or hate groups. So you need to ask yourself, how are you going to handle that case? The first question you should always ask yourself is the complaint because of the content of the speech, or is it of a particular criminal action? Officers will respond to calls in which you need to decide whether this is simply freedom of speech or is it a crime. Two common calls you may be called out to are somebody's yelling loud, profane things or loud, racist, or offensive things, and the complainant wishes for you to make it stop. The second call you may get is gatherings of maybe hate groups or somebody else that is stating offensive things and people want it stopped. When responding to the call, the first question you should always ask yourself is the complaint because of the content of the speech, or is it the particular criminal action of the individual? People can say horrible things and still not commit a crime. If you respond to a scene because the complaint is the content of the speech, even if it's hateful, even if it's horrible, you cannot arrest somebody simply based on the content of what they say unless they're inciting violence. If you're unsure of what's going on, ask yourself if the person were doing the exact same action but yelling "God bless America," how would you respond? Would it be different? Cases indicate that probable cause to arrest for disorderly conduct cannot be based merely on words. Speakers do not violate the statute merely by annoying those around them, employing profane language to express outrage, or by using loud language or belligerent attitude. If there's a bona fide intention to exercise a constitutional right, the crime of disorderly conduct is not committed. In order to prove disorderly conduct based on words alone, the state must show that the words either caused a crowd to gather, resulting in safety concerns, or that the words incited a crowd to engage in an immediate breach of peace. Some examples where the courts found there to be free speech. Police were doing a narcotics investigation and asked a juvenile who was standing in a large crowd for his identification. There was no allegation that the defendant had committed any crime. The juvenile began yelling and using profane language, offensive speech during the encounter. The juvenile never physically interfered with the police. Disorderly conduct conviction was overturned because his statements were considered pure speech and not disorderly conduct. Officers responded to a break up a crowd that had gathered after a party. A female juvenile was in the crowd and was shouting and using foul language. Officers told everybody to leave the area and she refused. She continued to yell and rolled her eyes at the officer. There was fighting in the crowd, however, the officers were not able to testify that the fighting was anywhere near this juvenile or that this juvenile caused others to gather or fight. She was charged with disorderly conduct and resisting without violence. The courts overthrew both convictions for her conduct because they found her conduct was based on pure speech and the officer was not in the lawful execution of his duties when she resisted. In this case, the defendant exchanged words with a young girl crossing the street to go to school. The defendant was an older male. One of the girls began crying from the exchange and told the SRO about the incident. The SRO approached the man to see what had happened. The defendant repeatedly yelled at the officer to mind her own effing business. The SRO attempted to talk to the defendant's wife, who was also in the car. The defendant got out of the driver's seat, began walking over to the SRO, waving his finger in the SRO's face and screaming obscenities at the SRO. There was testimony that traffic was slowing down to watch the encounter, but no one from the cars testified. The courts overturned the conviction for disorderly conduct because it found that it was mere speech. The courts did find a crime in the following cases. First, customer repeatedly refuses to accept a store return policy. repeatedly attempted to devise plans to thwart that policy, was loud, cursing at employees at a return counter, refused store managers' requests to leave the property, interrupted police officers' questioning of the manager, refused to comply with the officer's orders to move. Defendant's nonverbal actions constituted more than mere words and were found to be disorderly conduct. Defendant came into the police station in reference to posting a bond for his father. The defendant began screaming obscenities. Officers behind closed doors from the back of the station could hear him and came to investigate. He was asked to quiet down or leave on several occasions. The court said that although it was a close call, it was not the content of the speech which made it a crime, but the volume and disorderliness in which were the issue. Because the nonverbal conduct resulted in the interference of peaceful operations of the police department, which took the event outside of protected speech. I do want to caution folks, though, however, just because we have a belligerent person in the lobby, this should be a last resort and solely focus on the actions. Advice. So when you arrive at your scene and you believe this may be an issue based on speech, ask yourself, if they were saying something else, would you enforce the law? For example, as I indicated, somebody's yelling in the middle of the sidewalk. If the person's yelling, "Jesus loves you," or "God bless America," would you treat the person the same? You should always be treating these people the same. If it is simply speech, please be very careful with any enforcement. It's likely you will have to walk away. You can, however, look at other avenues. For example, if this is a mentally ill person, maybe a Baker Act would be appropriate, maybe a Marchman Act. If there's a trespass involved, or in a park after hours, those are types of cases that you can enforce. But simply yelling obscene things or gathering as a hate group and saying obscene things is not sufficient to get you into a disorderly conduct. The next section we're going to briefly go through are First Amendment auditors. First Amendment auditors, as you know, will come into our police department lobby, they'll go into police parking lots, they'll go to government buildings, and they will try to look suspicious in order to get a reaction from our police officers. They are hoping that you'll tell them to leave, they are hoping that you will stop filming them, that you'll take their camera away. If you take any of these actions, they will immediately file suit against the city, they'll begin making public records requests, they'll post videos of you on their website. All of this is an attempt to elicit a police response. Typically when you go out to these calls, it'll quickly become apparent as to who you are dealing with. Please remember these individuals have a right to videotape in public places. They can also film government employees engaged in government duties in public. Please do not tell them to leave. Please do not tell them to stop filming, and please do not take their camera away. If you encounter them and leave, they will move on to the next city. So some tips when dealing with a First Amendment auditor. First, when you encounter a First Amendment auditor and you realize what you're dealing with, the biggest tip I can tell you is try to disengage from that person as fast as possible. Second, they will like to quiz you on all types of Fourth Amendment, Fifth Amendment issues. Am I being seized? Am I being detained? Am I legally allowed to be here? Am I legally allowed to be there? Remember, you do not need to engage in their pop constitutional quizzes. It is okay that once you realize who they are and they start asking you those questions, to say, "Have a nice day, sir," and walk away. 3. While we should give them a lot of leeway, we do not have to allow them to begin testing or making odd requests. For example, if they come up and want to start doing tint testing of your vehicle by opening your door and putting a tint meter on your door, you do not have to permit them to do this. Balance your dealings with the outcome. Recent trends of these is you've seen the armed phishing, which we have a training tip that has gone out on. They'll want to start washing police cars to get a reaction from you. They'll demand that you allow them to tint test your police vehicle. We do not need to participate in that. Now, if they're outside and waving something over the window, that's fine, but we're not opening our windows for them to start doing tint testing.
Notice that your tint is below your AS1 line right on your car. And I was going to see if you mind if I check your tint on your window real quick, just make sure it's legal in the state of Florida.
If they want to film over the fence of a secured cop lot, as long as they are in a lawful place filming, we cannot stop them. And as always, with any of these, if you have any questions, feel free to contact your legal advisor.